Good morning, everyone. Thank you for having me today. My name is Natalie Staub. I'm the project manager for the Specialist Disability Accommodation, and I'll use SDA from now on, implementation project. A little bit about us. I'm not sure if you've had much to do with Consumer Affairs Victoria. We're basically Victoria's consumer regulator. Some of the work we do, we provide advice to tenants, landlords, property owners, consumers on their rights under our relevant acts, and we also enforce consumer law in Victoria. So today I'm talking to you about the changes to SDA tenancy law. So on the 1st of July this year, changes were made to the Residential Tenancies Act, which introduced a section which covers now specialist disability accommodation. This new section, as it's set out, is Part 12A, if you ever need to dig into the legislation. And it does a few things. So probably most significantly is it creates a new type of agreement called an SDA residency agreement. And what that is, it's been designed specifically for SDA residents. It brings across many of the protections that formerly existed under the Disability Act for residential statements, and it brings it into the Residential Tenancies Act. So while it continues some of the protections from the Disability Act, it also increases some of the protections available to SDA residents, and it brings it into line with the rights available to other tenants in Victoria. So limiting a landlord's right to enter a property, being able to seek the help of the Director of Consumer Affairs for non-urgent repairs, and also go to VCAT if they have issues with their tenancy. So under the Residential Tenancies Act, there is the SDA residency agreement, but what will also be available to SDA residents potentially is a regular tenancy agreement. So that's like a standard lease that people will enter into when they enter into a rental agreement. So there are some limitations around that, but there are two types of agreements that are potentially available. So the purpose for that was to allow the choice and control for a person, which is in line with the policy of the NDIS. So what that does enable is for an SDA resident to live with family or friends. We've had a case of a mother who has MS, and she wants to live with her child, and they can now enter into a tenancy agreement. Also a case of a couple who want to live together. He's got a physical disability, and so now they can enter into a tenancy agreement as a couple and stay together. One of the additional features that's been introduced to the Residential Tenancies Act is protections for an SDA resident who enters into a tenancy agreement, so the regular kind of lease, against coercive or deceptive conduct. So it's really important to note, and this will be important for the kind of advocacy sector, is that someone entering into a tenancy agreement that has a reduced level of protection as compared to an SDA residency agreement. So it's really important to note they cannot be forced or coerced to enter into a tenancy agreement. We can talk about that a little bit more in a minute. So just a little bit about the role of advocates under the Act. The Residential Tenancies Act explicitly recognises support people in the Act. Some of the, and this will be kind of, you'll be recognised as kind of a chosen person is the language. So some of the explicit roles in the Act for support people are to help the resident understand the agreement that they're entering into with the SDA provider, to help the resident understand any forms or notices that they're given by the SDA provider, to help the resident apply for urgent or non-urgent repairs, and there's other general support. So it doesn't limit the support you can provide, but it's explicitly built into the Act. I'm going to talk about the two types of agreements in a bit more detail and note some of the key differences, and I'll talk about kind of your role during that. So I thought it was important to highlight some of the differences between the two types of agreements that will be available to SDA residents under our Act. So up here I've got the SDA residency agreement and the tenancy agreement. The SDA residency agreement is only available to SDA residents, that is NDIS participants with SDA funding. It's also available though to Commonwealth continuity of support clients. So they're the two people who qualify for an SDA residency agreement. A tenancy agreement is open to all Victorians, so it's just a regular tenancy agreement. There are really important distinctions in starting an agreement between the two agreements. For an SDA residency agreement, there's the process of entering into, which means both the SDA provider and the resident will sign the agreement, or you can establish the agreement, which is consistent with NDIS policy, where the resident doesn't have to sign the agreement in order for it to be valid. And there's some steps the SDA provider needs to take to establish the agreement, but only the SDA provider needs to sign it at the end. And this is because the person may not be cognitively able to enter into a contract. So that's the reason for that. With a tenancy agreement, the provider and the resident has to be able to sign the contract. So there is kind of a test, it's not built into the legislation, about a resident needs to have the capacity to enter into a contract in order to become a tenant under a regular tenancy agreement. And this is really important, and we realise that this is going to be an area that may get tested, and we've been talking with Tenants Union of Victoria, but I just wanted to highlight that as an important distinction today. Also, some of the things we're kind of hearing as the SDA providers are starting to try and understand these new types of agreements. The SDA residency agreement is an agreement between the provider and each resident in a property, so they're individual agreements. A tenancy agreement is one agreement for the whole property, so all the tenants need to be able to sign it. There are some provisions for subletting, but they're really important distinctions, and maybe something to look out for if you do have a client who has a tenancy agreement, and just to look at how that may have been set up. So this is kind of something we're hearing, that maybe there is a little bit of confusion about how these agreements might work in practice. Another important distinction between the two agreements is damages. So under an SDA residency agreement, a resident does not pay for damage caused by their disability, their behaviour related to their disability, or any equipment needed for their day-to-day living. In a general residency agreement, the tenants are responsible to pay for any damages. So that's a really important protection built into the SDA residency agreement that doesn't extend to a tenancy agreement. Sorry, yes, down the back.
I have a question about people with intellectual disability, if they're unable to sign a residential tenancy agreement,
Yep.
but they're not granted SDA in their NDIS plan.
Right.
What happens? Is there anything in between? What does the law say?
I can't speak to that. I suppose it depends on what kind of agreement they're living under currently. I would recommend for those kind of questions on a case-by-case basis that you do give Consumer Affairs Victoria a call. Like I said, it's not written into kind of the Act about there's no test of capacity, but a contract needs to be between two people who can understand and enter into it. So please give us a call in those cases just so we can explore that further, if that's okay. So I'll move on to notices to vacate, and this is an SDA provider asking a resident to leave. Under a SDA residency agreement, a resident needs to be given a notice of temporary relocation before giving a notice to vacate, and that's for a minimum period of 90 days. So you can't ask someone to leave without first finding them suitable temporary accommodation. There are also notification requirements that an SDA provider needs to notify the NDIA, the Office of the Public Advocate, the Director of Consumer Affairs, and the resident still provider, I believe, when they're given a notice of temporary relocation, and they have to notify those people within 24 hours. The purpose being is that it then triggers kind of a support around that person to make sure that the accommodation is suitable and they're given appropriate accommodation. Under a residential tenancy agreement, there are laws around giving a notice to vacate, but it's more around the minimum notice period, so those protections aren't in place. With regards to ending an agreement, and this is looking at the SDA resident, under an SDA residency agreement, an SDA resident can end the agreement at any time by giving a notice of intention to vacate to the provider. Under a regular tenancy agreement, there are time periods associated with it, and there might also be lease break costs as well. So they're just a few of the kind of key distinctions. And just to say, everything I'm talking to you today is available on our website, and there is a section for support people as well, where the information's been a bit tailored to that group. So please do go online, and there'll be more information about these agreements. I thought it'd be worthwhile. So what's happening at the moment? The legislation came into effect on the 1st of July, and SDA providers have until the 1st of January 2020 to enter into an SDA residency agreement or a regular tenancy agreement with their existing residents. The purpose being that after the 1st of January 2020, the protections available under the Disability Act, residential statements, will no longer exist. And will become void. So if they haven't entered into a new agreement, the resident won't have the protection of the Residential Tenancies Act or the Disability Act. They'll become a tenant at will. So there are some safeguards in place, but that's the reality of what will happen around that time. And we're working with the department, the NDIS Quality and Safeguards Commission, and the NDIA around making sure there are protections in place for residents around the 1st of January. So the process that's happening, and this is a process for entering into or establishing an agreement. So the first step is the SDA provider gives an SDA residency agreement or a residential tenancy agreement to the SDA resident. And ultimately, the SDA provider can decide which type of agreement that they will offer in their SDA dwelling. We have been attending some sessions with SDA providers to set this out, kind of noting that the type of agreement they choose will then determine the type of residents that they can welcome into their property if someone was to leave. So they choose a type of agreement that they want to offer. We know that DHHS will be only offering SDA residency agreements in their property, notwithstanding that there are some TAC clients, for example, who don't fit under the SDA resident definition, and they're looking at that on a case-by-case basis. So step 2 is the SDA provider gives the resident the agreement, and there's also an information statement for the SDA residency agreement and the tenancy agreement. So they have to give both things to the SDA resident. They also have to explain the agreement and the information statement to the SDA resident. If they believe that that resident would benefit from support in understanding it, they are also required under the legislation to give a copy of the agreement and the information statement and explain those documents to a support person or a chosen person, which could be really anyone chosen by the SDA resident. So family, carer, advocates, for example, are listed out. So it's built into the legislation that the SDA provider must seek support for that client if they need help in understanding it. If the SDA provider, if the resident doesn't have a chosen person, then the SDA provider must find them someone, and that person can't be employed by or associated with the SDA provider. It's also, I wanted to note too that the SDA agreements and information statements are prescribed products, which means that they've been prepared under regulation and approved by the Director of Consumer Affairs. The SDA residency agreement can't be changed. So an SDA provider can't make amendments to the agreement. It's as is. There is a space in the document for additional terms, which is something that's probably really important to look out for. Everything in the SDA residency agreement aligns with the NDIS terms of business and protects the rights of the SDA resident. If there are additional terms, it links back to what Hannah was saying about unfair contract terms. They have to make sure they comply with Australian consumer law and they don't take away any of the existing rights within the residency agreement or within the residential tenancy agreement. So if you are seeing additional terms, I would recommend kind of keeping an eye out for them. And if you've got any concerns, please call us at Consumer Affairs Victoria so we can help answer any of your questions around that. Also, if you're noticing there are some changes to the agreement, please also give us a call. We're really interested because this is a new piece of legislation. Please do let us know. We're interested in understanding how this is actually being rolled out in practice. So the agreement's been explained to the resident and any support person. The resident has to have a minimum of 7 days to consider the agreement. The next step is the SDA provider and the SDA resident. If the SDA resident agrees to the agreement, they enter into where they both sign the document or establish the SDA residency agreement. So the establishing is only for the SDA residency agreement. If it's a tenancy, they both need to sign. The SDA provider then gives a copy of the agreement to the SDA resident and keeps a copy for themselves. If they've entered into an SDA residency agreement, the SDA provider must notify Consumer Affairs Victoria within 14 days, and we maintain a register of SDA residency agreements. And that register is available to the Office of the Public Advocate for their community visitors program. So another thing to kind of point out is community visitors have rights of entry like they do now for properties where they've entered into SDA residency agreements. If it's a tenancy agreement, they don't have the same rights of entry. They can be invited to come and visit the property, but they just can't go out and visit as they have normally done. So that's how the Office of the Public Advocate will be made aware of who is living under an SDA residency agreement in an SDA dwelling. So I know I've flown through what is quite a significant change, but I would really encourage you, we do have a lot of resources available. Firstly, if you've got any questions or concerns, you want to understand the Act further, you've got a client who's entering into agreement and you've got some questions, please do contact us on our SDA inquiries line. We've got staff who've been trained in this legislation and on the NDIA too, and they will be your best first point of call for answering general questions on these new agreements and on the Residential Tenancies Act. So please start there. It's Monday to Friday, 9 a.m. to 5 p.m. Please also call them to, even during the agreement, if there's any concerns about notices that have been given, urgent and non-urgent repairs, the inquiries line can answer all those types of questions. As I said earlier, our website, Consumer Affairs Victoria, has information for residents, providers, and specifically for support people, which goes through in detail all these new requirements under the Residential Tenancies Act. So if you haven't already, please go and have a look. You can download a copy of the residency agreement and information statements. The information statement is quite a comprehensive document, which will help you understand the different types of agreements and the rights and responsibilities for providers and residents. I want to also note that we have produced easy English versions of both a tenancy and an SDA residency agreement and the information statements. They're available on our website. We'll be producing easy English versions for all the forms and notices that are related to SDA. We're also developing a visual aid for SDA residency agreements to help SDA providers or support people guide SDA residents through the transition to new agreements or entering into new agreements down the track. So that's all I had covered in my presentation. I know it was very quick, so if there are any questions. Okay, thanks very much.
Thank you, Natalie and Hannah. Has anyone got any questions for either of them before we break for lunch? Han, can you wait for the microphone?
Hi, my name is Amy. Thanks for this great presentation. I was actually very impressed coming back from Europe to Australia. I just actually wanted to have those two presentations by both Consumer Affairs Victoria and CLAC Solicitor emailed to myself. It will be very beneficial for myself.
Yeah, all the resources.
I know actually. I would like to say to other people as well that those new legislations will be enforced, and you know who is there to assist us in the future. Yeah, thank you very much.
All the resources from today will all be available online later on as well, so you can access them later as well.
Oh, right, excellent, thank you.
Okay. And if there's nothing else, we can now break for lunch, and I would like to see you all back here at 1 o'clock. Thank you.